Good afternoon. To start it off, let me introduce the panel again, since most of you weren't here this morning. To my right is Tom Greenholz from Chattanooga or Hamilton County. To my left, if I can get it out, is Matt Wilson from Jackson, Madison County, and I'm Bobby Holloway from Columbia, Murray County. So everybody knows you got 20 minutes. If you want rebuttal, let us know at the first. We've read the briefs, but we haven't read the record. All right. Let's call the first case.
State of Tennessee versus Albert Franklin Thompkins Jr.
Judge Tom Greenholz, Judge Robert Lee Holloway Jr., and Judge Matthew J. Wilson, if it would please this honorable court, I am requesting to reserve brief rebuttal time. My name is George Edward Samuel Pettigrew. I, along with the appellant's sister, Miss Rochelle Thompkins, are here on behalf of the appellant Albert Franklin Thompkins Jr., a family man with a family name. The appellant was wrongfully convicted of 2 counts of aggravated sexual battery and 2 counts of rape of a child in Knox County, Tennessee, before the Honorable Judge Hector Sanchez, who was in his first jury trial after being appointed. Now, I kind of saw how everybody slumped down in their chairs and took a breath when I said wrongfully convicted after jury trial. Although I did make a sufficiency argument as my first argument in my appellate brief, that is not the focus of my argument here. I previously clerked for Gary Wade when he was the presiding judge of the Court of Criminal Appeals before he went to the Supreme Court, and I fully understand this court's hesitancy to disturb a jury verdict. Here, due to an abuse of discretion in denying the appellant's motion for mistrial, that's why we're here. I stand on my brief as to the sufficiency of the evidence argument, but the appellant defendant was denied due process and his constitutional right to present a defense based on the denial of the mistrial motion. And those are the third and final arguments made in my brief, and I'll address those arguments later. But as I stated in my brief, I believe that this court will have no sleepless nights when you eventually reverse the trial court. What I'm here to talk to you about are the 3 points of reversible error and the abuse of discretion committed by the trial court. The first being a violation of the spirit of Batson when the trial court dismissed the only African-American male from my client's jury pool. That argument is number 2 in my brief. The second error is that of the trial court denying the appellant's motion for mistrial based upon felonious witness intimidation and the resulting non-appearance of all duly subpoenaed defense witnesses. That argument is number 3 in my brief. Finally, and the third point of error, here the trial court erred in denying the appellant's motions for mistrial and a motion for new trial. That's argument number 4 in my brief, and necessarily incorporates all of argument number 3. And first, the trial court erred by dismissing the only African-American juror from the jury pool. And yes, the selection of the only African-American male was through random drawing. And yes, the appellant's jury pool still contained 1 African-American female. However, race and gender are issues in this matter. During my voir dire of prospective jurors, I spoke to those prospective jurors about the issues of racial disparity and of gender disparity. It is unfortunately common knowledge that our prisons and criminal justice system as a whole are made up of and processed through, like a conveyor belt, African-American males.
I wanted to ask you about the spirit of Batson issue. At that point, when it's done at the trial court, the trial judge has to make a decision.
Correct.
That is the race-neutral reason. So there was nothing on the record in this case, given there was no, that's why we're under basically a plain error standard of review, right?
And again, it was through random drawing. It was through random drawing. And it's my experience, Judge, that when a trial judge draws out, from the random drawing, a number, right? They either draw 2 or they will draw 1, and if the jury consists of 1 African-American juror, they will put that number back and draw again so as not to run afoul of Batson. But here, we had 2 African-Americans that was on the panel. There was a situation where he drew it out, and the only African-American male, and again, this is African-American male, so it's a little outside of Batson. But that's the argument that I'm making, Judge.
Oh, I've spent 16 years on the trial bench, and I can't imagine drawing, even if I draw an African-American male out on a random draw in the deselection process at the end of the trial,
Correct.
Putting that name back in and drawing somebody else. I mean, I've never heard of that process. And you say
not based in the rule, is it?
Excuse me?
So that's not based in the rule.
No,
It's not
it
based in
is
Rule
not.
24.
I'm just saying
Sorry, Judge.
practically.
I can't imagine how that is not discriminatory on the judge's standpoint. I've just never heard of doing that. It is random and it is anonymous when you deselect the alternates. I just don't see how Batson comes into play in that process.
And I understand, Your Honor.
Well,
But,
can I ask you about first principles?
correct.
First principles. The rule in Batson, from where does it spring?
Excuse me?
From where does the rule in Batson spring?
Well, the rule in Batson springs from, does it not spring from judicial opinions?
It springs from the 14th Amendment, right?
Correct.
Okay. It springs from the Due Process Clause of the 14th Amendment, the Equal Protection Clause of the 14th
Correct.
Amendment. All right. So in an equal protection challenge under the 14th Amendment, can you have liability based upon disparate impact
No,
on a constitutional claim?
I don't believe so.
In fact, that's right? So you have to have evidence of intentional discrimination.
Correct.
And that's what Batson says, that
That is
all
correct.
of Batson's 3-step process is a proxy for determining intentional discrimination. And so when you say it violates the spirit of Batson, the spirit of Batson, reduced to its essence, must be invidious intentional discrimination, not practices that have a disparate impact.
Correct, Your Honor.
So
And
where's the evidence of intentional discrimination?
And that's why I was very careful to say this was through random drawing. And
Sure. Where's the claim, though? The claim must have some basis to it. So where's the proof of intentional discrimination?
I would concede that there is not intentional there.
That
But
necessarily defeats the claim, then, doesn't it?
It does, Your Honor. But I believe that, and my argument goes to the fact that this was the only African-American male juror. Because it was drawn as the only African-American male, it's my position that that should have been placed back. But I do understand the court's rationale on
It's
this.
not a rationale. There's no basis in the rule that would allow a trial court judge the discretion to put struck jurors back, right?
Yes, you're correct, Your Honor.
Are you aware of any authority addressing this issue?
No, Your Honor, and if I did, it would be in my appellate brief, so.
There is a case from the Ohio Court of Appeals from 2018, State versus Lamb. Are you familiar with that case?
I'm not.
Okay, all right, fair enough.
Respectfully, none of us are black males. We don't know what that potential discrimination feels like, and neither did anyone on the appellant's final jury panel. When the trial judge excused the only African-American male from the appellant's jury panel, the spirit of Batson, it is our position, was violated, and my African-American male client, Albert Franklin Thompkins Jr., was denied a fair trial by a jury of his peers. Next, the trial court abused its discretion by denying the appellant's motion for a mistrial based upon felonious witness intimidation and the resulting non-appearance of all 8 duly subpoenaed defense witnesses. Here, the victim making the allegations of aggravated sexual battery and rape of a child is a minor, a teenager, 13 years of age. Prior to the trial of this matter, a 404B hearing was held. Present at the 404B hearing were some defense witnesses, the appellant's live-in mother of his minor child, and an alibi witness. Ruth Ann Sharp, their minor daughter, another minor, Kyra Story, the appellate defendant, the minor victim, she's a minor, should I say her name or just initials?
Just initially.
MB, and her mother, and biological father, Dion Brabson. As litigation continued and intensified, the trial court took a brief recess. During that recess, we were in criminal court 2 and exited out on the city county building onto floor 1. And most individuals that were participants went down to either the main floor or to the cafe there in the city county building. During that break, I, as appellant's counsel, was approached by an emotionally distraught Ruth Ann Sharp. She told me that while she and the defendant's minor daughter were walking up the steps from the main floor to the first floor, they were confronted and accosted by the minor victim's biological father, Dion Brabson, who told her, quote, "If you or anyone else show back up to court, I will fucking kill you and your entire family." When I was told that, Your Honors, I, as an officer of the court, was concerned, but Ruth Ann Sharp was emotionally shaken. I immediately went to the assistant district attorney who was handling the case, Ashley McDermott, explained to her what I'd been told, and together she and I met with Judge Sanchez in chambers about what had happened. Judge Sanchez that decided that because emotions were high, and since the defense case in chief wouldn't begin until Thursday, all defense witnesses should be excused until Thursday. And Judge Sanchez ordered the same from the bench and stated, and I quote, "Let's settle this in court." Thursday rolls around, the state rests their case, and there are no defense witnesses present. Neither is Dion Brabson, the minor victim's father. So 0 out of 8 subpoenaed witnesses, no one's there. Judge Sanchez asked the defense if I would like to call my first witness. Again, no subpoenaed witnesses there, no alibi witnesses, no one. As trial counsel, I began explaining to the judge, well, unfortunately it appears there's no one here. Let me use my cell phone. I can call or text, try and figure out why no one's in court. When suddenly, the double doors to criminal court 2 sprung open, like a scene from a Grisham movie, and there was an unknown white elderly man standing there, and he walked in and pointed at me and said, "Ruth Ann Sharp's out here, and he wants to talk to you." And that kind of took me by surprise. I looked at Judge Sanchez, I didn't know how to proceed. And you could hear Ruth Ann Sharp crying just outside the door. Judge Sanchez took a recess in order that I and General McDermott meet with Ruth Ann Sharp, talk, and figure out what's going on. We went out there, and Ruth Ann Sharp tells me, "They burnt my house. It's gone. I can't be here. I won't say anything." Again, all contrary to everything that I had gathered from her during my trial prep and witness interviews in defense of Albert Franklin Thompkins Jr. General McDermott spoke with Ms. Sharp and got Investigator Tipton from the Knoxville Police Department to kind of look into the situation. Later, Investigator Tipton confirmed that there was one was a house fire, and 2 had been put out on Glenwood at the scene. We met with Judge Sanchez and Judge Sword in chambers. Judge Sword is criminal court 1 in Knox County, but again, because this was Judge Sanchez's first trial, he kind of called in another judge. Again, it was with General McDermott and myself, so there was no error there. They asked what I would like to do, and I explained to the court, I need Ruth Ann Sharp to testify, but she's not in any condition to right now, because after she made the statements to Investigator Tipton, myself, and General McDermott, she walked in the court, sat down in the witness stand, and was stating over and over, I can't be here.
So this all took place after the alleged threat, is that correct?
Yes,
okay,
that's correct.
So she's back in court. Judge Sanchez tells her to come back. She says, "I want to testify today."
Yes.
And then she doesn't show up within the next 30 days.
That is correct,
Is
Your
that
Honor.
right? All right.
Judge.
So help me with this. It seems like you're asking us to take a lot on faith. Because none of these witnesses were presented on a motion for new trial.
Correct.
None of these witnesses were presented on an offer of proof.
Correct, Your Honor.
We have a witness showing up after the alleged threat at least once. And so you're asking us to infer a lot about witnesses' motives. You're asking us to infer a lot about what they would have testified about, but none of that's contained in the record. So what do we do about that?
That is correct, Your Honor, and that's really just why I'm making this oral argument.
I understand.
And I do understand that the record does not have doesn't have the information, and I understand this is an appellate court and it's a court of record. I understand that, Your Honor, but I just have to put this out before the court because this is what happened, and Judge Sanchez understands as well.
What's the process? It's been a while since I've been involved in something like this. To get a witness who's under a subpoena to court, can't you have some kind of instanta subpoena issued and have the police department, I understand you may not testify favorably, and have her picked up?
Yes, that is the process, Your Honor. And that process was extended to the defense. Because Albert Franklin Thompkins Jr. was my client, and because he knew about what had happened earlier, he knew about the fire, he asked that not be done. And I understand that is really a legal determination. I would argue it's a legal determination as opposed to one that my client would make. But I respected my client's wishes. I did not ask Judge Sanchez to send out officers to go to the school where the minor was or go try and locate Ruth Ann Sharp.
I guess, so it was the victim's natural father.
Correct, Your Honor.
So it's not someone that the state, it's not the state, and it's not even the victim.
No, exactly. It's not the state. And then I want to make that very clear. This was something that was the fault of neither the state nor of the defense, which is why when I made my motion for a mistrial, it was absolutely the ideal situation where manifest justice requires a mistrial to be granted, in my opinion, because this was not a situation where the defense had done something or the state had done something that caused these individuals to not be here.
Have any criminal charges been taken out against the person that you say threatened these witnesses?
Not that I'm aware of, Your Honor.
What's going to happen if we were to reverse and send it back for a new trial? Why would we not end up in exactly the same place we are now?
Oh, you are absolutely correct. This is a situation where all of these individuals' testimony is forever tainted. That is my position, which is why I asked not for a curative instruction and it to be sent back. I'm asking for this to be reversed, Your Honor. Because it is my position. I'm out of time now, but it is my position that this was a situation where it's not possible to do a curative instruction, to do something to send it back on remand for a retrial, because every single individual who was on my defense subpoena list, none of them showed up. The only individual that showed up and testified on behalf of Mr. Thompkins was his sister, who was not subpoenaed. So I used the term with her when I was explaining what had happened. It's almost like I was putting out a hit list. And, she was there to support her brother, and she offered all the testimony that she could because she knew everyone that was involved, and she did testify as to Mr. Albert Thompkins babysitting her children, his nephews, nieces, things like that. So again, for the foregoing reasons, Your Honor, respectfully, we are moving this court for the convictions for aggravated assault and rape of a child to be reversed. Thank you, Your Honors.
May it please the court, Brent Sherry for the state. This case is a little unusual. We've heard opposing counsel talk about some things that aren't in the record, which are new to me, quite frankly, for this hearing. What I look at, and I think what this court is required to look at, is what we have in the record. So based on that, I've made my arguments, my brief, and I'll rely on that as we go forward here. Now, the defendant has not talked about the sufficiency issue that was raised in his brief. I won't go into a lot of detail about that, therefore. But I would just point out that this case is unusual with respect to many child sex cases where we see a forensic interview come in, which is admitted into evidence and is played for the court, and then the child victim presented, and there's an opportunity for the defense to question the child. This case is a little bit different because here the child appeared and testified about the details of the case all the way through, and there was no forensic interview that was admitted into evidence. In this case, the jury had the opportunity to hear and see the child victim witness, and later heard the mother testify, and I think you could say an almost brother who testified, a friend that was actually the son of the defendant, who talked about the revelation of this abuse. So the jury had the opportunity to hear all this, as well as hearing the police officer who interviewed the defendant, and they heard and saw the recording of that interview, so they could weigh and measure all this together, make their determination as to the guilt of the defendant, and of course found him guilty of 2 counts of aggravated sexual battery and 2 counts of rape of a child. I think that this court already understands very well the problems with the Batson claim in this case. Judge Sanchez randomly selected 2 of the 14 jurors simply by drawing their numbers out of a box to be alternates and relieve them from further participation at trial. And this certainly is not something that could be in any way viewed as discriminatory or to have a racial foundation. It's about as non-racial as we can get. Simply draw a couple of numbers out of a box. As a young man, I came from a fairly rural area out in the Northwest. We didn't have a lot of race issues where I grew up. So when I joined the Marine Corps and got shipped off to Virginia, that was really my first experience with large numbers of people from other ethnicities, other races. And one of the things my drill sergeant told me, as well as all my brothers in arms at the same time, was the Marine Corps doesn't have black or white, doesn't have yellow or red. It has one color. We're all green. And so that's the way we were trained, and that's the way we lived. In this case, when the judge looked at these jurors, the numbers were in a box. There was no distinction of race or even gender. There were simply jurors, all equal. And there's certainly no violation of the spirit of Batson in the way that issue was managed. As far as the motion for mistrial is concerned, I have some sympathy, perhaps some empathy for the defense, because many years ago I was a young defense counsel, and there was a lot of frustration at times working with witnesses. Sometimes you weren't sure what they were going to say, and sometimes you weren't sure if they were even going to show up. And I recall on many occasions taking measures to make sure that my witnesses would show up for trial, because otherwise I thought that they just might not. But that's just a frustration and a matter of course in dealing with defense witnesses. Sometimes they show and sometimes they don't, and what can you do about it? But the judge, in a case like this, has a different perspective and a different matter to resolve. When he's talking about the mistrial, what he has to look at is what has happened here. Has somebody done something wrong? And do we have something that requires the court to take action to avoid a manifest injustice? And in this case, it simply isn't there. Ruth Ann Sharp showed up early in these proceedings. There's evidence that there was a threatening comment made to her, and she was shaken. And yet she showed up again. There's evidence that at some point there was a fire at her house, and yet she showed up even after that fire. Now, as far as what happened with the fire, what she told the court was there was incense burning. She didn't give any indication that that fire resulted from any kind of malfeasance, any kind of misconduct by anybody. It was simply an accident because she had her incense burning and it caught her house on fire. But at that point, the judge said, okay, I don't think she's competent to testify today because she's too shaken up. And the defense joined with that and said, yeah, I don't feel very good about having her come in and testify. Let's send her home. Send her home. And yes, she told the court, I don't want to come back anymore. I'm done. I don't like doing this. But they sent her home. Everybody agreed that she should be sent home. And she didn't show up the next day. Now, where is the manifest injustice? Now, what would she have testified to? In this particular instance, she had testified previously at a 404B hearing and talked about what she knew about the case, about the way she had interacted with the child and with the defendant. But there was nothing in that testimony to support any kind of inclination that she knew what happened, or that she could say that he was innocent. All she could say was he was a nice guy, he was okay with my kids, as did his sister when she testified. So when the court looks at all this together, what is there to suggest there is a manifest injustice, or that there is a necessity for the court to kick this out and start over again? There is not any. Judge Sanchez properly determined that the mistrial, the motion for mistrial, should be denied.
Were there any efforts made to use her prior testimony at that 404B hearing?
Nothing in the record. Nothing in the
So-
record, Your Honor, no.
That she was unavailable, no motion made? Okay.
Nothing in the record. All we have is just that she didn't show up for that next hearing, as was the same with all the defense witnesses. They just weren't there. The trial court is responsible for managing the court and doing the best he can with what's presented by the counsel, by the state, and by the defense. But in following the rules of the court and in managing the administration of justice, when we have a motion for mistrial, there has to be a basis for it. There has to be a showing of manifest necessity, and it simply wasn't here. The state presented its case, and the jury convicted the defendant fairly and properly, and this court should affirm that judgment. There are no other questions.
Thank you, Jerry. All right, rebuttal?
Just say, Your Honors, if not here, where? If not
On the
now-
motion for new trial.
Excuse me.
On the motion for new trial,
I
that's where,
understand, Your Honor, and we did make those allegations in the motion for new
so
trial.
that's where you had the opportunity to offer proof, though, to support the allegations. So if not here, where? It's on the motion for new trial.
Understand, Your Honor. But again, none of these individuals were making themselves available to me. And I understand what the Attorney General is arguing in opposition. But this is a situation where none of my subpoenaed witnesses were here after a credible threat from the victim's family, a confirmed house fire at the scene of the crime, and where my witnesses lived. Yes, she came back to court, and yes, she said she wasn't going to say anything, she didn't want to be there, and she was emotional the entire time. Judge Sanchez properly found that she wasn't competent to continue testifying, but I would also kind of point out to the court, if she's not competent to testify then, how competent can we say, although all witnesses are presumed to be competent when they come into court, how can we say that anything she's saying, we can take parts of it and make bases and decisions based on that and just kind of randomly select? Again, Your Honors, I understand the court's difficulty and the likely outcome, but again, this is a situation where I was left with no subpoenaed witnesses. I subpoenaed them all, I interviewed them all, I had what they were going to say, and unfortunately, so did the state. And again, I'm not saying the state made any improper actions, but manifest necessity is here because this was a very appropriate situation where I believe Judge Sanchez could have, and more importantly, should have granted our motion for a mistrial.
Again, and this is not some type of blanket statement, but I did some defense work too earlier in my career. As a defense lawyer, if I had to subpoena a witness, that scared me to death because that meant I didn't know what that witness was going to do, what he was going to say, and whether it hurt or help. And so, I just don't understand what we have in this record that's going to support what you're asking us to do.
I understand your words, and you are correct. But this is not, seems silly for me to tell the Court of Criminal Appeals they are correct, but it's a situation where my client had a due process right to present all of these individuals' testimony to the jury and let them make a determination as to what weight they give to what they're going to say, whatever that may be.
But he also had other remedies. And
Correct.
he didn't exercise his other remedies. Could have asked for a continuance. He didn't ask for a continuance. Could have asked for the sheriff to go get them. He knew where one of them was. He affirmatively disclaimed it. He had other remedies. There were remedies short of stopping the trial. And so I agree. He has the right to subpoena power. He didn't exercise that right by asking the sheriff to go out and get the witnesses.
I understand you.
And you can make them testify or be subject to contempt. There's just a lot of things that didn't happen that I don't know how we're going to get around.
I understand, Your Honor. Again, it was a situation where I kind of deferred to my client, and maybe that's an error that I should not have done. But given the high emotions that were kind of present in court during all of these things that were going on, that's the decision I made. Thank you, Your Honor.
Thank you, Mr. Rediger.
Thank you, counsel. Thank you. Sure, thank you.
All right. Ready to call the next case?